Good afternoon, everyone. Uh, you'll have to pardon me if I'm a little unprepared because the topic which I read was challenges in implementation of open access. And since I'm dealing with a lot of consumers in the state of Maharashtra, I thought I can just speak impromptu rather than being prepared or having a presentation or something. Now, when it comes to open access, the way it was envisaged is that it will come down to a level where even you and me as a resident will be able to select the supplier from whom which we want the power to be. But unfortunately, even after the 2005 regulations, that is 11 years, we are unable to come down from 1 megawatt. Now, in terms of challenges or the disconnect, which I would say is after the 2016 regulation, obviously it has a long history. If I have to touch upon the years prior to 2016, then year on year we have had issues with the utility on the open access. But when it comes to 2016 regulation, which was quite a welcome change by the industry at large, the disconnect is on the implementation. It seems that there is no specific directions or guidelines which the utility has while evaluating the application. So month on month or maybe year on year, each time a client comes to us, he says that the regulation says XYZ, whereas the utility is asking another ABC as well. So what does the consumer do? Now, unfortunately, not everyone has an opportunity to seek any legal assistance. Half of them do not have access. Some of them do not, probably envisage that they can do a litigation. A litigation in India, as you all know, is time consuming as well as expensive. Also, what challenge which I see from the consumer or the industry, even if it's a large industry, they don't want to mess with the utility because their interaction with the utility is obviously on day-to-day basis. So definitely they don't want to touch upon sticky issues and want to get it resolved. But according to me, or probably it's a suggestion to MSCDCL, that maybe to their circle offices or to every level at every officer should be aware on how the open access has to be implemented. If you see the regulation, there is a provision where they were supposed to issue a guidelines or a directive on the steps or a procedure which they need to follow, which till date has not come into place. Also, there are other issues like contract demand, reduction or reinstatement of contract demand. Now, as a utility, maybe yes, it's an issue, but there are certain things which I think can be automated. So, for example, if someone is opting for a short-term open access and has reduced the contract demand, okay, in that case, maybe there can be some automation which probably MSCDCL can upgrade their softwares or do something wherein the contract demand is automatically reinstated once the open access is terminated or the period has expired. When it comes to other challenges which we have is on the enforcement. Open access has long history and MSCDCL has obviously plethora of litigations with the consumers in Maharashtra. So there are certain things which are precedent. There are various judgments which have been given by the Honorable Commission as well as the Appellate Tribunal or maybe Supreme Court. And time and again, obviously, it is not enforced in the way it should be enforced. So every time someone wants to have something in their favor, they can't run to the commission. I also feel like, this is a food for thought for all the dignitaries here and maybe they can take up with the policy makers that there has to be certain more empowerment in the Electricity Act or teeth to the act. Because as a consumer, you are not interested in a utility paying a fine or they are being punished. What you are interested is barely with what you are getting and open access. Now, when it comes to open access, why people want to have open access? Because obviously the rate is more competitive, not that they have any animosity with the utility. They are opting for open access only because they can get competitive in this market. And all of us are aware that there is a recession in the market where every industry is suffering. If we want to encourage Make in Maharashtra, even MSCDCL as a utility will have to be more competitive. The genesis of having unbundling of the utility was that there should be more competition. The captive generation was de-licensed. Private players were invited. All this is, there is a background to it that people wanted generation distribution business to be more competitive. And I think if MSEDCL or any other utility puts their house more in order, sensitizes people across their network on how we can get more competitive, how the softwares can be developed, I think this can be achieved. I don't think I need to touch upon the other issues which my all learned seniors have already touched upon, that Maharashtra is facing the issue. And my earnest request to everyone here is to find out a solution where year on year we don't have an issue in implementation, and a special request to Mr. Deshpande that we should find a solution where there are only identified procedures or documentation which a consumer comes. Like, I have heard, like, there are instances where sometimes even the RPO related details are required, which is obviously not in the scope, and it is in scope of MEDA. So that is something which, like, delays as the process. And once it is delayed, and as we rightly said, that justice delayed is justice denied, sometimes like, going back or revisiting after 6 months, even if after an order I get an open access, sometimes it may not be worthwhile because the economics, the combinations, everything must have changed by then. So with that, I would want to close my short presentation. Thank you.